Hello, I'm not Chuck, and today I want to bring you up to speed on a U.S. Supreme Court decision. The decision is primarily about homeless people, but it may affect you if you are an RVer or a van dweller. On December 16, 2019, the U.S. Supreme Court released a list of orders based on recent decisions. Toward the bottom of the first page, under a heading that says certiorari denied, there is a single line that reads 19-247, Boise, Idaho v. Martin Robert et al. That is Supreme Court shorthand that means it has refused to review a decision made by a lower court. Let me read a few lines from a press release from the National Law Center on homelessness and poverty. This morning, the U.S. Supreme Court denied a petition by the city of Boise to review the case Martin v. Boise, formerly Bell v. Boise. This leaves in place earlier rulings by the Ninth Circuit that homeless persons cannot be punished for sleeping outside on public property in the absence of adequate alternatives. People experiencing unsheltered homelessness, at least in the Ninth Circuit, can sleep more safely without facing criminal punishment for simply trying to survive on the streets. The Supreme Court's decision, issued without comment, means the April 2019 ruling is binding in the Ninth Circuit, covering 9 states, including most of the western states, and carries national influence. The ruling also means that homeless individuals who have received criminal citations under Boise's policy can now proceed with their constitutional claims against the city. That's the end of the press release quote. Here's a short excerpt from the Harvard Law Review dated December 10, 2019. A decade ago in Boise, Idaho, it was illegal to sleep in public. One ordinance banned occupying, lodging, or sleeping in any place without permission. Another barred the use of any streets, sidewalks, parks, or public places as a camping place at any time. Janet Bell was cited twice, once for sitting on a riverbank with her backpack, another time for putting down a bedroll in the woods. She pled guilty and received a 30-day suspended sentence. Robert Martin, who has difficulty walking, received a citation for resting near a shelter. He was found guilty at trial and charged $150. On October 22, 2009, Bell, Martin, and 9 other homeless people sued the city. They claimed that the enforcement of the ordinances violated their Eighth Amendment rights, criminalizing them for carrying out basic bodily functions. Under Section 1983 of U.S. Code Title 42, they sought expungement of their records, reimbursement for fines, enjoinment of enforcement, and a declaration that the ordinances were unconstitutional. That's the end of the quote from the Harvard Law Review. In case you have forgotten, here's the wording of the Eighth Amendment to the Constitution of the United States. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. You expected more? Well, there is no more. That's the entire Eighth Amendment. Section 1983 of Title 42 is a little more wordy. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress, except that in any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. For the purposes of this section, any act of Congress applicable exclusively to the District of Columbia shall be considered to be a statute of the District of Columbia. Section 1983's basic premise could be restated as simply as this: any person whose constitutional rights are violated can sue to be compensated, which is just what Bill, Martin, and the other 9 homeless people in Boise did, and thus began a series of back-and-forth legal decisions. Now remember, it started in 2009 when the homeless plaintiffs filed their suit. In 2011, the district court found in favor of the city of Boise. In 2013, the Ninth Circuit reversed that decision and sent the case back to Boise. In 2014, the district court once again found in favor of the city of Boise. In 2018, the Ninth Circuit found in favor of the homeless plaintiffs. In 2019, the city of Boise appealed to the U.S. Supreme Court. In addition, 20 other groups and organizations filed friend of the court briefs in support of the city of Boise. The lawyers for the homeless plaintiffs filed a brief of opposition. On December 16th of 2019, the U.S. Supreme Court announced they would not review the case, which effectively left the Ninth Circuit ruling in place. Whether you agree with their decision or not, the Supreme Court should be congratulated for their promptness. Los Angeles City Attorney Mike Feuer had urged the court to hear the Boise case and review the Ninth Circuit's opinion. He said, "The lack of clarity of the Boise decision, combined with its sweeping rationale, makes more difficult the efforts of Los Angeles to balance the needs of its homeless residents with the needs of everyone who uses our public spaces." He also questioned whether the city must have shelter available for all 36,000 homeless people before taking enforcement action against a single unsheltered individual who refuses an available shelter bed in one of the city's regional shelters just because shelters at the opposite end of the city are full. Maria Foscarinis, executive director at the National Law Center on Homelessness and Poverty, said, "We're thrilled that the court has let the Ninth Circuit decision stand so that homeless people are not punished for sleeping on the streets when they have no other option. But ultimately, our goal is to end homelessness through housing, which is effective and saves taxpayer dollars, so that no one has to sleep on the streets in the first place. We hope that the Ninth Circuit decision will help communities find the political will to put that housing in place. Housing, not handcuffs, is what ends homelessness." That's the end of the quote. Of course, the decision made by the Ninth Circuit is binding only in states and territories in the Ninth Circuit: Alaska, Arizona, California, Hawaii, Idaho, Nevada, Montana, Oregon, and Washington, plus Guam and the Northern Mariana Islands. But it is probable that challenges to laws in other places similar to the Boise laws will be brought in more U.S. Circuit courts. It is unlikely that all other circuit courts will agree with the Ninth, and unless they do, the U.S. Supreme Court will ultimately be asked to review the lower court decisions and reconcile any differences. However, that scenario will most likely take several years. After all, the process with Martin v. Boise has taken 10 years to work through the courts. So, what does all this have to do with RVers and van dwellers? First, in the states not in the Ninth Circuit, laws that bar homeless people from camping on public land may continue to be enforced, and in some cases may be unfairly applied to people living in RVs, vans, and the like. In addition, some public lands may be closed to camping altogether in order to avoid the issue. Second, in the states in the Ninth Circuit, more homeless people may take up residence in RVs and vans, some of which will be parked on public streets. As a result, RVers traveling in the Ninth Circuit may be erroneously identified as homeless and poorly treated. Camping space may be harder to find, especially in urban and suburban areas. Of course, that's just my opinion. Thanks for watching, and remember, I'm not a lawyer, and I'm not Chuck.